You're doing well. You have created your will, you've built your will, you've built, or rather put in the information for your enduring power of attorney. Now we move to the medical power of attorney. Of course, that's not the name of a medical power of attorney. That's just what lawyers call the medical power of attorneys or power of guardianships. There's 8 different names depending on which state you pick. So, for example, if you picked Western Australia, Tasmania, or New South Wales, then you are building enduring power of guardianship, more usually called a power of guardianship or a POG. If in Victoria, you've got the strange and obscure name of appointing medical treatment decision maker. And where we might use the word attorney, the correct expression in Victoria is decision maker. Quite bizarre that they would come up with that terminology. Then we've got our capital city, Australian Capital Territory in Queensland. They use enduring power of attorney, which is very similar to the standard enduring power of attorney. South Australia Advanced Care Directive and Northern Territory Advanced Personal Plan. So depending how you answered the question before, we answered New South Wales, but let's now make it Queensland. Then the power of attorney and medical power of attorney will be compliant with Queensland laws, and the building process will change slightly depending on the rules of Queensland, including what we see when banks in Queensland look at a Queensland power of attorney, or in this case, what a medical power of attorney, or to be more correct, because we're in Queensland, an enduring power of attorney looks like when you take it to a nursing home. Best practice. We follow best practice. Now, some people would say, well, I've got children. They make the decisions for me if I can't. That's not true. That's not true. There's a hierarchy of power, and the highest power is you. While you're of sound mind and you're not feeble, you can speak to the doctors and nursing homes. You are it. You're the decision maker, provided you're over 18 and of sound mind. After that, it's not your family or spouses or parents. It's the person holding the power of guardianship, the medical lifestyle power of attorney. If you don't do this document, then you are allowing the government and nursing homes and doctors to have more control of your family. Now, I'll give you some examples that our law firm, Legal Consolidated, has been involved in. In this case, it was a Victorian client. He, a very wealthy gentleman, he had put his wife into a 5-star nursing home. Most beautiful, lovely food, white tablecloths, very nice. But he wanted his wife out. He didn't want her to be there for reasons that don't matter for this discussion. He went to the nursing home and they would not release the wife. He rang up almost in tears, and he was a big burly businessman in his youth. And we advised him, one of my lawyers advised him to take the medical decision maker to the nursing home, and he did, and he got his wife out. You get more control with the medical decision maker. We had another situation which is also common where his wife was unable, she was in an unconscious state and unable to give advice, and therefore the medical power of attorney kicked in. And in this case, it was a Queensland, so the power of attorney kicked in, and he was able, against the doctor's advice, but with the advice of other doctors at another hospital, he was able to require that his wife be removed from that hospital in an ambulance to attend at another hospital. And he could only do that because he had that power of attorney in Queensland. So yes, you do, as a spouse and children, you'd have a lot of power, but not as much as you'll have under this document. How do you choose your person? Well, everyone picks their children, spouses, parents. If you don't have anyone, then talk to your closest friends and ask if they'll carry out the job. Look, it's a tough job. I mean, it's not just the nursing home, it's also dialing up the morphine on the last day of your life. These are big decisions, and generally your closest friends or your family will want to be involved in that. Well, what can they decide? What can they actually do? So we've put in 5. There's 5 things they can do. Every state's slightly different, but the rules are pretty much based on each other. All 8 jurisdictions follow a similar pattern. And we put the order of what they can do in how it's actually used from our experience. So this is not necessarily the list you'll see if you go onto a state government website or you'll go to the court or whatever. So the first thing we see is the power is used mostly to deal with doctors and how you will be treated when you can no longer speak to the doctor. Palliative care, life-sustaining measures. Time and time again, clients come to me and say, if I'm a vegetable, I want to be knocked on the head, which of course is illegal. That's called murder and you can't do that. But if you are a vegetable and you've clearly explained that to the people that you've appointed, the decision makers, then they can, in certain circumstances, decline for you to have certain medical treatment. Very difficult situation. The next time, or the next grouping of powers that we see most commonly used in these types of powers is where you will live. You can no longer, you've got full dementia, you're wandering around the streets. It's not safe for you anymore. We did have a carer come into your house. You got plenty of money, and we did have a carer come into the house, but it's not enough. You need 24-hour-a-day care, and I think a little bit more than that. So we've made the decision. Me as your oldest son and my 2 sisters, your 2 daughters, have made the decision that, Mum, you don't know this because you've got dementia, but we're going to move into a home. We've got that power. We signed, or you signed rather, a power of a guardianship many years ago, appointing myself and your 2 daughters, the 3 of us, to hold that, and we decide to make that decision. That's the next most common. Then these other 3, who you live with. If it's the case that we had this situation where a lady was alcoholic, and she moved another alcoholic into the house. She got dementia. As soon as she got dementia, the medical power of attorney kicked in, and not me, but the clients removed that alcoholic lady from the house. But that's the only time since 1988 that I can remember this clause being used. And the other 2 I've never seen used. So whether you work and related decisions. You've got full-blown dementia. You're probably lying in bed, gurgling away with some oxygen on your face. I've never heard you going off to work. It's just bizarre. And even more bizarre is what education and training you receive. So maybe we'll get you back to university to be an engineer. But if you probably wouldn't be using, your children or spouse would probably not be using the medical power of guardianship if you're in that situation. I've never seen them used. States are all different, but that's pretty much the 5 powers. Now, you'll see here that at this point, I've only appointed 1 attorney or decision maker, depending which state you're in. I'm going to add a 2nd. And just like with enduring power of attorneys, a new clause will apply. I had to press something to make it do it. There we go. So I will have, in my case, my 3 children acting separately. That's most, again, like your enduring power of attorney, that's most usual. What we've seen. Oh, look! Before I tell you what we see is, I just let you know that in Western Australia you don't get that choice. Every state gives you that choice, but in Western Australia you don't get that choice. There's no, you can answer the question, but it won't come up in your document because you just don't get the choice. Now, how we found in Western Australia is that if it's a minor issue like cutting your small finger off because you've got gangrene, one child will be enough. But if it is a big decision, then they want to speak to all two or three of your family members. Obviously, if you appointed your spouse, then they're just going to speak to the spouse. So putting Western Australia aside, it's an outlier. It's the only one. In all other states, you have the right to pick together or separately what you're going to pick. Normally, again, it's a question for your priest, not for me as a tax professor in tax law. But what we find mostly is that people will pick separately, like they've done with their enduring power of attorney. So if you've got more than one, then I'm going to have three in this instance. Then I'm going to have them act separately. Oh, Professor Davies, that's a big decision for, big decision. Well, I'll tell you how it works in real life, and you don't get this in textbooks, but I'll tell you how it works. If it's a minor issue, then they'll just talk to one child. If it's a big issue, even though you've said separately, they're going to want to speak to all the children or all the people you've nominated. That's how it's been working in practice in all states of Australia, including Western Australia. So your choice, you can make them act together. One of the reasons I find together, and my wife and I we've marked separately for ours. One of the reasons is it's quite often becomes an urgent question to be decided in the back of a taxi. Back of an ambulance. even more critical if in the back of a taxi. The back of the ambulance, they will ask you a question, and if you have to act together, then might have to ring up the nephew in Brisbane or in the Gold Coast or in Double Bay in Sydney, and that can become quite time consuming. But your call. A lot of people do pick together, but most will pick separately. So that's the power of guardianship. We're going to move to having substitutes or backups.